All right, let's go ahead and get started. Hi again, my name is Sipra Boyd, and I'm one of the shareholders at Roberts Markel Weinberg Butler Haley. Happy to see everyone joining. I know that we had a large RSVP list for this topic because there has been a change in recent legislation. So I know everyone's interested in finding out what our thoughts are on the change and how to implement the change. As I said, I'm a shareholder with Roberts Markel. I am board certified in Property Owners Association law as well as residential real estate law. Very happy to have y'all here. Hopefully some of y'all can grab some lunch and listen today. I'm always happy to see people that are interested in education because that is near and dear to our hearts. So let's get started because I know there's a lot of information. Our quick disclaimer is that the information that's presented today is the law as it exists today. The effective date for some of the recent legislation was September 1st, so it's actually and officially effective as of September 16th. Remember that this information is just for educational purposes only, and it does not constitute legal advice. I know there are always really specific questions or issues that you guys are all dealing with on a day-to-day level, but as I like to say, for lawyers, facts really matter. And so it's really hard to answer a very specific question for your particular issue until and unless the lawyer knows all of the facts. So make sure that you do consult with the association's attorney if you have a specific question as it relates to the information we're going to talk about today. So more specifically, the bill that impacted what ACCs can do and how ACCs can operate and how boards can appoint ACC members was brought in through legislation and specifically Senate Bill 711. So we're going to talk a little bit about the Senate bill, the process for solicitation of candidates, and then more specifically who can serve on an ACC. And then we're going to talk a little bit about the roles and the responsibilities of the ACC, kind of dig in a little bit on architectural control guidelines and some more information regarding that. All right, so let's talk about ACCs in Texas and what the law says now. As I said, Senate Bill 711 was the bill that addressed several issues that I guess we struggled with from probably the 2019 legislative session. The topics that were included in Senate Bill 711 for the 2025 legislative session were all addressed in Senate Bill 1588 in the 2021 legislative year. However, it was one of those bills that was vetoed in that big list of bills that was vetoed by the governor towards the end of the session. So Senate Bill 1588 was approved by the governor and then later vetoed. So Senate Bill 711 was really just kind of a refiling of Senate Bill 1588 and addressed lots of other issues besides just ACC. But like I said, today we're going to focus on the ACC aspect of it. There were provisions regarding condominium management certificates. So for any of my associations that are condos, we're not going to talk about that today, but make sure that you are updating your management certificates as required by law and including any of those fees that are charged in connection with a closing. There were also some really good changes, excuse me, to the security measures statute. So those need to be updated as well. And then obviously what we're going to talk about is that it started or it added a solicitation of candidates process for the ACC. And specifically, I'm talking about the Architectural Control Committee. There are various names for those types of committees. We globally call them ACCs for Architectural Control Committee, but you could have Architectural Review Committee, ARC, the Modification Review Committee, New Construction Committee. There's all sorts of names, but essentially it's the committee that is typically appointed by the board that reviews and approves modifications to the property. And then it also clarifies the membership process and who can serve on the ACC. Okay, in terms of the notice of solicitation for candidates, the way that the bill reads, it's a little bit confusing, but essentially the bill requires a solicitation process before the board can appoint or elect candidates to the ACC. Probably 99% of the associations we represent, the board has the authority to appoint ACC candidates. There are a few associations where the ACC is actually elected, similar to a board. And so this provision applies to either one, whether they're appointed or elected. And essentially, what it requires is a notice of solicitation for ACC candidates before the board appoints or elects the ACC members. And y'all have seen this before. The process is similar to what the solicitation of candidates is like for board members. And so essentially, the notice has to be provided by one of the following, either mailing the solicitation to each owner that lives in the subdivision, or by posting the solicitation in a conspicuous manner in a common area or on an internet website maintained by the POA and sent via email to each owner who has registered the email address with the POA. Make sure whenever you're doing the notification process for the solicitation that it's clear on the instructions, essentially 10 days before the ACC is either elected or appointed, the notification should be sent out. You need to give them at least 10 days to respond. So try not to cut corners. I would give yourself, a couple of days on either end, allow time for mailing or for people to open their emails and get the information. And it's really important to put specific instructions on how the solicitation can be returned, as well as the date by which the solicitation has to be returned. And again, you have to give them at least 10 days. In terms of the ACC membership requirements, if you remember, I think in the 2019 legislative session as well, under 209.506, the ACC and the board members have to be separate. And so essentially, if you serve on the board or on this ACC, you cannot serve on the other. A board member cannot serve on the ACC. The spouse of a board member cannot serve on the ACC, or a person residing in the home of a board member cannot serve on the ACC. And so those are still requirements under the new law. However, the process that has been implemented as a result of Senate Bill 711 is that as long as you go through the solicitation process, as I just explained, and if there is a vacancy that remains after the solicitation process, then the people that would otherwise be prohibited from sitting on the ACC can now sit on the ACC. So once the vacancy, it's clear that there is a vacancy, and that happens as a result of really no responses to the solicitation process, or maybe you do get responses and they're either a board member or a spouse, but you have to go through that solicitation process. And if there is still a vacancy that remains, and that could be one of three positions, it doesn't matter. Typically, the number of committee members is usually controlled by your governing documents, but sometimes it doesn't say. We would typically recommend that, the ACC, if you can get three people, that would be ideal. So after the vacancy remains, you've gone through the solicitation process, given everybody at least 10 days to respond. The board now has to decide who can serve. And there's no one interested, or there's one person interested and there's 3 spots. At that point, if there are open spots for the ACC, then the association board can appoint a board member's spouse, or someone that cohabits or resides with a board member. Remember that the solicitation and the membership requirements that apply under 209 don't apply during the development period, which is specifically defined while the developer essentially is still in control, and it does not apply to Chapter 82 condominiums as well. So that's kind of the process now. I know that there are still some questions about, well, can we still hire a third-party company to perform the functions of an ACC? I think that as long as the restrictions, the dedicatory instruments of the association allow for um, that duty to be served by a third party company, then the board has the decision to do that as well. I see some questions in the chat, and we can talk about it a little bit more. What if the people that have responded to the ACC solicitation aren't qualified, or the board doesn't think that they would serve as good ACC members? It's a really good question, and I think you have to be careful. I think that if you don't have a lot of candidates that are interested, and let's say there's 3 positions and there's only 3 spots, I think you really have to do your best to be able to fill those 3 spots with the 3 people that are interested, and not try to create a vacancy because you don't think that they're qualified. And I'll take a minute to talk about qualified. The role of the ACC is not intended. I know that this is a difficult kind of pill to swallow, but it's not intended for ACC members to have some professional or particular type of expertise in reviewing ACC applications. And I personally have an issue with this because I get it that it's hard to read ACC applications. Sometimes it's hard to understand the requirements, right? And the restrictions, the setbacks, the easements, just all of the nuances that are on maybe the plats as well. There might be information or limitations on the plats, but really they're not, the ACC members are not supposed to be specialized or particularly qualified. They're just supposed to look at an application and make sure it conforms with the requirements under the dedicatory instrument. So is it violating a setback? Is there a drainage plan included? All of those requirements that are supposed to be reviewed by the ACC members should be able to be reviewed by a regular owner or a regular resident in the association. So my opinion would be, to the extent that you can fill those spots with non-board member or board member related spots, even if maybe one person or some of the people aren't qualified, and give them an opportunity to serve, because I think that's the purpose, is to let as many people serve as possible. So let's jump back into the presentation in terms of architectural control guidelines. I didn't specifically mention those, but as part of the ACC's role, they are reviewing the architectural control guidelines and making sure that the ACC application comports with guidelines, because not all of the restrictions or limitations as it relates to the ACC applications are going to be in the restrictions. There might be some in either later adopted guidelines or potentially guidelines, builder guidelines that were adopted during the development control period. Technically, legally, the purpose of the guidelines is to kind of establish the aesthetics for the improvements in the community, and that it ranges with a wide variety of issues, right? What does the home look like, and the elevation, the materials that can be used or not used, which are prohibited, the colors, and also it has to do, or they should also address other issues such as fencing or landscaping or accessory buildings. They can serve to dictate guidelines around all of the other appurtenances related to the improvement. Swimming pools, things like that. So they are meant to more specifically address the aesthetics of the community. They can also arguably, right, clarify some ambiguities that exist in deed restrictions. And so an example I like to use for clarifying an ambiguity, and it's not really an ambiguity, but really more specific information, is if the restrictions call for homes to be painted in earth tone colors. Sometimes there's deed restrictions to a certain degree are subjective. And so sometimes earth tone is not necessarily your earth tone colors are not my earth tone colors. And so I think a way that architectural control guidelines can help clarify or provide some more specific information is to maybe list the hues or the colors that are considered earth tone, greens, browns, whatever it is, those fall colors maybe. And so that's a helpful way for ACC guidelines to supplement the deed restrictions. Really important if you have architectural control guidelines or if you're drafting or creating architectural control guidelines, I encourage all association board members to work closely with their management company and their law firm, because you want to make sure that any guidelines, and that kind of runs the gamut with policies, anything that the association board adopts later does not conflict with the restrictions, the declaration, the CCCRs. You want to make sure that if particular colors or materials are permitted under the declaration, that you're not adopting something that later that says those are prohibited, because that's not the proper way to amend the declaration. Obviously, the declaration typically has a higher threshold for how it can be amended. So, for example, if your fence limitations under your declaration actually say fences must be at least 6 feet tall, and you want to allow 4-foot fencing, then you can't just later adopt a guideline that says they can be 4 feet or 6 feet if it says that they must be at least 6 feet in the declaration. So you want to be really specific, and you want to be clear, and you want to make sure that you're not contradicting something that's in your deed restrictions. Also, just a reminder that there are several provisions in Chapter 202 of the Property Code, and those typically do apply to both single family and townhome associations, as well as some condominium associations, but they address use restrictions. A lot of them deal with solar panels or landscaping, or roofing materials, religious displays, flag displays, a lot of things that we would typically include in architectural control guidelines. And so you want to make sure that your guidelines don't specifically prohibit something that is permitted under Chapter 202. Right, so you can't prohibit U.S. flags, not that you would, but U.S. flags are protected. You can't prohibit religious displays. Religious displays are protected. So you want to make sure that your guidelines don't contradict both your restrictions or state law. And then really important is that guidelines are a dedicatory instrument. And basically a dedicatory instrument is defined throughout the property code as really a document that defines or dictates or governs the subdivision. And so we consider dedicatory instruments kind of the whole, I guess, the entirety of all of the governing documents that impact the association. So that would include your articles of incorporation or your certificate of formation, your bylaws, your architectural control guidelines, your deed restrictions, any supplements or amendments thereto, any of these policies that you would adopt under Chapter 202. And so what is really important is that anything that's considered a dedicatory instrument under the law, if you intend to enforce it against an owner, it must be properly adopted in an open board meeting, and it must be recorded in the real property records of the county in which the community or the subdivision is located. I'm still seeing, and this has been the law for quite some time, I'm still seeing associations say, this is the rule, and it's been the rule for quite some time. And I often ask for, where can you point me in which document that this rule is listed or stated? And oftentimes either they can't, or the document exists, but it hasn't been recorded. And so it's really important to make sure not only that it's properly adopted in an open meeting under Chapter 209, but also that it's recorded. again, if you intend to enforce it. I've already kind of touched on the specifics in terms of the architectural control guidelines, but there is a lot that you can do with guidelines, and specifically, addressing things that aren't necessarily provided for in the restrictions, again, as long as they don't contradict the restrictions. But I already talked about colors of exterior paint or trim, fencing requirements, landscaping requirements, the location and size of ancillary structures, swimming pools, patios, decks, you name it. You can really do a lot with architectural control guidelines and dealing with specific issues that come up that may not be addressed in your deed restrictions. Another good purpose for architectural control guidelines is to kind of help homeowners understand the architectural process for how to submit an application and how to get approval, right? So we all like to hope and assume that whenever a new owner purchases property in a community, that they've read chapter and verse everything that they were given all those 100 pages of documents that you get at closing, including your deed restrictions, and so they know how to. They know that, or they're assumed to know. I guess they're charged with constructive knowledge that they have to go through this application process before they modify their property. But as we all know, that's not true. People don't read what they sign. They don't read what they're given. And then there are a lot that do know that and just would rather ask for forgiveness rather than permission because they're probably doing something that's against the deed restrictions. So regardless of what the reason is, I think it's helpful when guidelines, which again are recorded in the real property records as well, also lay out the architectural control process. And so how do you submit an application? Where do you go to get the application? Maybe it's just a statement that, the association's management company, maybe there's a website. What needs to be included in the application? I know a lot of us are going to the digitized world, right? And so a lot of restrictions talk about submitting actual plans, and now we can accept digital plans, and then that's how most people are functioning these days. So what needs to be included in the plan? I've had a couple of instances here recently where the deed restrictions call for the inclusion of a drainage plan. And so if a drainage plan is required, you need to make sure a drainage plan is submitted. That doesn't mean that someone on the ACC has to be a drainage expert and has to understand and learn what the drainage plan says or if it's accurate, but that there is a plan for drainage that has been included and considered during the application or the design process. How long responses should take to receive, and potentially even items that may not require ACC approval. I struggle with this one, but for example, if you're changing the exterior paint of your house, but you're not changing the color, you're just repainting it because it needs an update. Possibly that might be an instance where you don't need to get ACC approval. I struggle with it because you don't really know if it's the same paint color until it goes up there, and sometimes it's not. We've had that issue happen before because fresh paint looks a lot different than paint that's been on a piece of property for 20 or 30 years. So, but I do think that's helpful because that kind of avoids clogging up the ACC application process, because I know that there's lots of modifying going on or new construction in a community. And so it helps kind of limit the number of applications that the ACC is having to review. If you can put something in there that doesn't need to be reviewed. In terms of the approval process and violations, I really think it's very important that the ACC and the board understand that despite whether there is a timeline to respond in your deed restrictions that the ACC is responding timely. So you might, under your deed restrictions, have 30 days or 45 or 60 days to respond to an ACC application. But just remember, you're kind of the stopgap between the homeowner trying to start a project for modifications that they've potentially already paid for. And so there are contractors that are waiting for them. There are suppliers that may or may not have supplies. If you're delayed a week or two, things happen. We all know what happened during the pandemic. And so despite what it may say in your deed restrictions, make sure that the ACC is acting as promptly as possible. If there is additional information that the ACC needs in the approval process, in the review process, make sure that you're responding back quickly to the owner and saying, we're missing information and you need to provide additional information. It's helpful, even though we don't want to necessarily have to babysit our owners and have to constantly be the ones that remind them what they need. It is helpful if there are items missing for the ACC to be specific, not just say you're missing information, we're not going to look at it. And in that vein, also really important if you are missing information as the ACC to not just say we're missing information and not do anything, because in our opinion, not responding, even if there are items that are missing, doesn't necessarily save you from a deemed approval. If you have 30 days to respond, an application is missing information, and the ACC just doesn't act or just says it's not complete, so we're not going to respond, you're really going to have a tough time convincing a judge that that was reasonable. I think it's better to say, the application is denied, or the application process is paused, and the the response time will not start until the information is provided. Some type of a response is better than just saying it wasn't complete and we're not going to respond. I will tell you that deemed approvals, especially if the homeowner relied on the deemed approval and started construction, is a very, very difficult hurdle to try and successfully challenge in a court, because courts don't just look at the black and white of what the restrictions say. They also review decisions based on equity and what's equitable. If a homeowner has spent $10, $20, $30, $40, $50,000 on a deemed approval because the ACC didn't respond timely, then we're, based on equitable principles, the court might say, look, guys, I'm not gonna get them to tear this down. So really important to be responsive. I kind of said all of what's on this slide. The approval process starts when the application is received. So don't wait the full 30 minutes or the 29th day to say, approved or denied for this reason. Try and act. I know you guys are all busy and this is volunteer and it's very thankless, but if you can, try and respond as quickly as possible, even if the information in the ACC application is missing. And on top of deemed approval issues, one thing I didn't mention is that you could also be subject to allegations that there were unreasonable delays. And so there are other legal theories like latches or equitable or estoppel, that play a role into the ACC not responding timely. I know that for some of our drafters in our firm, we are starting to write restrictions that don't have that automatic deemed approval. They actually have an automatic deemed denial, which I think that's very helpful, especially in instances where we're not responding timely. It's actually deemed denied, but I still think, again, it's better to respond either way and make sure that the homeowner understands what they may or may not be missing. And just to understand that the ACC has has the application, but there's a problem with it. The approval process and violations. So in rare instances, and I say rare because I think that we're going to talk about variances. In rare instances, there may be a variance that's required. Now, variances really need to be reviewed and considered thoroughly. The way that most restrictions are written, variances are only appropriate in extraordinary situations where the topography of the lot or the setbacks, because of the way that the lot is structured, make it really difficult for the homeowner to build the structure that's required to be built on that property. So whenever you're considering variances, or if there's something in the application that requires the homeowner to violate some type of a setback or some other restriction, make sure that it's kind of a unique one-off situation and you're not just granting variances for ease or convenience. And I get that a lot of applications, all these applications, the design process, the architectural process is time consuming and expensive. And so homeowners have spent a lot of time and money on on these applications, and they might want a variance because it's easier and maybe less expensive to build a particular or modify a particular structure in the manner that they're requesting, or because they just think it looks better. It's not necessarily because it's difficult for one reason or another. And I'm not telling you that just because it's aesthetically pleasing, that's not a basis for a variance, or just because it's easier. I just am reminding everyone that it really should be kind of a hardship issue. It should be kind of the exceptional reason to grant a variance rather than the norm, because the more variances you grant, the more that you dilate your restrictions. And so if you're allowing setbacks to constantly be violated, if you're allowing elevations to be modified or changed, or colors or materials to be changed based on variances, then just know that later on down the road, if another application is submitted, you're going to have a hard time pulling that back. It's a slippery slope. It's a slippery slope. And then if and when at a later time the board or the ACC wants to be a little bit more strict or stringent on a particular issue with a homeowner, the homeowner can come back and basically argue that the restriction or the setback has been waived because we've allowed so many variances for that particular issue. So just be mindful during the approval process, especially if there's a variance involved. The denial process is really important, or the approval process is really important. I've had several instances where, it was approved or it was conditionally approved, but it doesn't necessarily say what the condition is. It's important to try and be as specific as possible if there is a conditional approval, and advise the homeowner what the condition is, and make sure that when you are reviewing applications that you're reviewing them thoroughly, because once they are approved, I've had this instance happen a couple of times too here recently. Once they're approved, it's really hard to call that approval back. Maybe easier if construction hasn't started, but I'll tell you, I don't want to be the attorney in the courtroom that has to argue that the homeowner has assigned approval, and now we're suing them over the approval. So these are serious, right, processes that we have to pay really good attention to. And while I'm sitting here telling you to be diligent and try and not unreasonably delay in responding, if you need additional time to make sure what you're approving is in fact approvable and should be approved, take that day or two or week or whatever, discuss it with the attorney, discuss it with the management company, do whatever you need to make sure that the approval is in fact approvable and not just a rushed application. We've also had instances here recently, lots of stories with deed restriction violations where what was approved was not what was constructed. And so, it depends on your particular association, how you implement this, but it's not just as easy to, I know the ACC process is not easy, but it's not just about approving the application and then kind of forgetting about it, right? You have to approve the application, and then someone or something, whether it's your management company or the ACC or the board members, need to make sure that what's being constructed is somewhat in line with what was approved. So that if you've approved a 2-story structure, when you're driving by, you're not seeing some type of a 3rd floor go up. There needs to be some kind of checks in place to make sure, or inspections to make sure that what was submitted is being constructed. And that might mean in your approval letter reminding homeowners that if something is approved and there are changes along the way, that they will more than likely need to submit a new application or a modification application for an approval. I think before I get to this next slide, what I want to remind everyone also, in previous legislative sessions now, there is a requirement that the denial letter be very specific. In the denial, explain why the application was denied, and then also give the homeowner, it has to give the homeowner a right to appeal that decision, the denial, to the board. And so really important to make sure your approval and denial letters are really specific and comply with the law. And so, I would encourage associations and management companies to make sure they're running those letters, at least initially, through their attorney, so that the information that's required to be included is in fact included. And then obviously in certain circumstances, there might be a need to involve the association's attorneys. I've had it happen in various stages, whether it's even just in the initial application process, like what do we do when we don't have a complete application? What do we do with an application that we're not sure how to handle? It looks like it complies, but we don't necessarily want this, or it's not in harmony with the subdivision, even though there's nothing specific that prohibits it. And then there might be just instances where a homeowner completely disregards the ACC process and just starts constructing, right? Or they start constructing something that again was not approved, or what was approved is not what was constructed or what is being constructed. And so again, I'll remind everyone that lots of time and money and energy is spent in this process. And so the sooner that the association can act and get either a cease and desist letter out, either from the management company, the association, or the attorney's office, the better, so that you can stop construction. Sometimes a TRO is necessary. A temporary restraining order is actually a legal action where a lawyer has to basically go down to the courthouse and file a petition that seeks immediate relief, a court order from a judge. And it is expensive and time consuming, because essentially you're trying to stop immediate construction. And we have to go down to the courthouse and find a judge, an ancillary judge sometimes, that will listen to the issue and hopefully be willing to grant some type of an injunction or a TRO to stop the construction. Sometimes that requires prior notice, even though in the law it's meant to be an ex parte hearing where notice is not required. The judges still make us run through hoops and give notice to the other side. So as much time as you can give to the other side and to your lawyers to try and hop in there and get the construction stopped, the better. And it'll be easier again on the back end for a judge to say, no, you've got to tear it down, or you've got to stop, or you can't go any further, if we get it sooner. Because the longer construction proceeds, the harder it's going to be for a judge to say, this $30,000 brick wall that you built, you got to tear it down, because that just doesn't seem fair, which I agree. If it violates the restrictions, who cares if it doesn't seem fair to the owner because they've done that at the expense of the restrictions, but that's just what judges do. We don't have control over that necessarily. Sometimes our associations want to be able to deny the review of an application or deny an application if the homeowner is either delinquent on their assessments or there are fines, maybe related to previous deed restriction violations or the current application in construction. And really the only time that is allowed or okay is if your deed restrictions are clear that the association or the board or the ACC has authority to not take action if the homeowner is delinquent on fines or assessments. I will tell you, in my too many years of practice, 20 plus years of practice in this area exclusively, that type of provision is very rare. So don't count on that type of provision to be in your restrictions. It is very uncommon for a restriction to say that the association can either deny or not review an application or refuse to review an application if the homeowner is delinquent on any amounts due to the association. Okay, I think a few more slides here, and then I see a lot of chatter, and so I'll try and leave some time to kind of go through the chat. In conclusion, Senate Bill 711 has basically a legislative solution to our vacancies that are on the ACCs, because I know a lot of our associations, depending on your size, and even if you're big, this is a problem across the board. Volunteerism is just an issue because, again, it's such a thankless job. But no longer is it against the law for a board member or a spouse or someone who resides with a board member to serve on an ACC, as long as the association follows the solicitation process and tries to fill those vacancies through that process. Obviously, the ACC process is a really important function of the association, not only the ACC process where the ACC is reviewing the application and determining whether or not something is approvable or should be denied, but then making sure that there are inspections and checkpoints along the way to make sure that the construction is constructing as planned. And then again, I can't say this enough. I can't tell you how many times, again, in my 20 plus years of practice, there's not been a response, or there's been a response that says, well, the application wasn't complete, so we didn't look at it. Don't do that. It really needs to be some kind of a response needs to be provided. And remember, I mean, ultimately the ACC process is to help. One of the, I guess, the most important tenets of the purpose of the HOA or the POA is to preserve and protect property values. So if there is upheaval and disorganization and a lack of processes and procedures in the ACC process, then your community is ultimately going to suffer on the back end in the way that it looks and its aesthetics, because then it's basically like the Wild Wild West, right? Then, well, why should I apply or submit an application because the ACC doesn't look at it timely, or they don't necessarily do anything if what was approved isn't necessarily what was constructed, or they're denying everyone and everything and they're not giving us a justifiable reason because it doesn't comport with the restrictions. So really important to have firm processes in place. And I really do think, the architectural control guidelines are a really important process, part of that process. Okay, I'm going to real quickly just kind of jump to the chat. But before I jump to the chat, I want to take a second to let people know that we are actively seeking positive Google reviews, because we think it's really important. The job that lawyers do in this industry and the education that we provide, especially through these webinars, is a really important aspect of community association living, and the tough job that we as professionals in the industry, managers, board members, the tough job that we have to do. And so we want to hear from you guys. We want to know good, bad, ugly, whatever. We want to know that you like these, that you want us to continue. We want to hear from you if you have ideas and other topics that you would like to suggest, if there are other formats. I think webinars are great, but I know that you guys are all busy, and probably half of you are trying to feverishly work while trying to kind of somewhat listen to me. You know, a lot of these are posted on our YouTube website. They're posted on our web page, and so you can look at these later. But I know what happens later. We get busy, and so it's not always the best use of our time. But anyway, we'd love to hear from y'all. This is a QR code. Please scan it and tell us how we can improve our services. And obviously, we'd love to hear from you. Okay, great. Well, then I'll just keep it on the last slide, and y'all can scan the QR code, tell us how we're doing. And then I will, oh gosh, doing a good job. I'm struggling today. I will go through these questions. The question that the first question I see is, do the current ACC members have to go through the solicitation process? I think if your current ACC members are in a term, and hopefully it's like a short term, like a 1-year term, then I think it's okay for them to finish their term and then go through the solicitation process. So you don't have to stop right in the middle of the current ACC board terms. Let's see, what else? What if the ACC and the ARC is still under developer control? So this is an exception for the development control period. There is an exception, so you don't have to follow this process. And there is an exception also for the limitations on the board membership. So not only do you not have to solicit, but you don't, board member spouses and related members can also serve on the ACC during the development period. What if the board does not believe the candidates are qualified to serve? Do they have to appoint candidates if enough vacancies remain? Again, I do think that I mentioned this, but I do think that unfortunately, we shouldn't really be prohibiting people from serving, even if we don't think that they're qualified, unless, again, if you have more than enough, and then, certainly you can determine who's best, but I don't think you should create a vacancy on the basis that they're not qualified, especially because, as I discussed, the role of the ACC shouldn't require any real specific qualifications, professional or otherwise. And you can certainly, if you think people are unqualified, consider reaching out either to your management company or Community Associations Institute or your law firm to see if they can do some type of ACC training on how to review applications. What if a member drops out during the year? How do we fill the position? So the solicitation process is required. So it says before the board can appoint or elect a person to serve in a vacant position, they have to go through this solicitation process. Are ARC control guidelines required now? No, guidelines have never been required. They're just, again, recommendations or suggestions. A lot of declarations that we read say that the Architectural Control Committee or the board has the authority to adopt and modify guidelines. And so I do think that they're recommended, but they're not required. Yes, I believe Kyle can let you know how to access the slide deck and the presentation after. What can you recommend that we say or do for boards that don't see a reason for adopting the changes since they are in the Texas Property Code? they said they are being redundant by asking them to adopt these guidelines. So my go-to response for boards that are, hesitant to, I think in their mind, waste money on attorney's fees, to draft policies and things like that um, uh, comport with the law, is that not all board members or ACC or associations know where to look in the law sometimes, or that a particular issue is addressed in the law. But hopefully they are familiar with their governing documents. And so what happens as boards change, as ACC members change, as management companies change, as lawyers, everything, is that there's that historical knowledge of how you do things, or the provisions in your documents that have been superseded by law, is gone. And you start relying on outdated documents. And so, if you're making sure that you're in constant contact with your lawyers and your professionals, your management companies, and making sure that you're following the law, that's one thing. But from my experience, boards don't want to spend money, and so they just kind of look at their documents and say, but our documents say this, and they may not know that there is either a property code provision, a business organizations code provision. Sometimes there are federal, Fair Housing Act laws that also kind of play a role in what ACCs or boards can do or should and shouldn't do. And so our best advice is to adopt policies and change restrictions as they change in the law. On the flags, have you ever had any issues with a stars and bars flags, also known as the civil flag of peace? I have not, but I will tell you that the law really just says that we can't prohibit an association or an owner from flying these three types of flags, right? The United States flag, the Texas flag, and then a flag from the military. Other than those flags, which are protected, the association has the authority to control the types and kinds of flags. And so what I will say is, if you are trying to prohibit one particular kind of flag over another, please make sure that there are specific guidelines or policies that allow for that. You shouldn't be saying your flag's permitted and your flag's not, or your flag is offensive and it needs to be consistent in order to avoid an allegation that we're acting arbitrarily or capriciously and allowing some flags and not others. Most guidelines must be voted and adopted by the same process as the declaration. So kind of a split response on that. Any dedicatory instrument or an amendment thereto has to be voted on and approved in the open session of a board meeting. So that has to be done. The approval or the vote process for that particular document depends on the type of document. So a declaration or an amendment or a supplement to the declaration usually needs the approval of a majority or 67% or some higher number of the total votes in the association. A board adopted policy, ARC guidelines, resolutions, things like those are typically just adopted with board approval, which is a majority of a quorum. But regardless of the number of votes or the type of votes required, ultimately it needs to be blessed. That approval by the board needs to be blessed in an open board meeting, at which proper notice is given to owners. I'll do a couple more. Solar panels, can they place them in the front because the company installing says the highest quality of sunlight? There's, the provision in the solar panels statute says essentially if there's a 10% increase, I think it's 10% in the efficiency or the output that's maintained by the solar panels, if it's in a particular place, then we have to essentially approve them. The only way around that I've seen is the board or the association has to hire a company to go out there and basically disprove that report from the owner's installer. And so now I'm just seeing that initially those are coming in showing that on the front it's better. And really the only way to fight that is for the association to be willing to put up some money to argue that that's not true. And that requires, hiring potentially a professional. Okay, so it's 12:31. I'm sorry about the issues with the slide deck. All I can think is I had an issue or a glitch with my computer, but this recording will be available. The slide deck will be available. Hopefully you guys find this helpful and informative. And again, we'd love to hear from you. So please leave us a Google review. And I hope everybody takes care. Have a good rest of your week. And we hope to see you again soon on our webinars. Thanks, guys.